So today we'll be focusing on equity and trust. So to give you an introduction, equity and trust is not really similar to other areas of law, for example, contract law, tort law, land law. Equity and trust is more about the legal concept and how the different equitable doctrines and principles, when they are conflicting, how we can actually reconcile the differences. um, so technically speaking, if you want to get a good grade for equity and trust, you not only need to apply the law correctly to the fact, and more importantly, you need to be really confident in your legal understanding of the different cases, the leading cases, and when when the legal principles and doctrines actually conflict with each other, and when there is such a conflict, what is your solution to that conflict? So some solutions might include, you try to say we distinguish on the facts, or you go to the law and say basically, this case wasn't really doing a good job because it was referring to a wrong case, or it was applying a wrong case on that fact pattern, and so on and so forth. So to have a good answer in equity and trust, you need to understand basically the entire legal landscape, the leading cases, and all the conflicts, as well as thinking about some solutions to try to solve the apparent conflicts, and obviously, excellent application of the law to the facts. So all of these actually make equity and trust the most difficult subject in law school. You actually have got a taste of this sort of more law focused subject in contract law, and then later on when you study tort law, it is much simpler, much more straightforward, in a sense that you actually, just for example, for negligence, you understand basically the full or five steps analysis, and then you go through them one by one, and basically based on that very structuralized approach, the problem is mostly on application of the law to the facts. Whereas for equity and trust, we need to understand the law very clearly. So let me start off with going through the introduction of the subject. So equity, in general, means a set of equitable principles and doctrines. And as you may have recalled from your legal system classes, or any related classes, that there is the merge of the Court of Chancery and the common law courts. So basically, right now we use one court to apply both common law doctrines and equitable principles. So the reason why there was equitable principle in place was basically to reduce the harshness of common law, which is basically a writ system. You need to fall within a particular course of action in a writ before you can bring an action to court. So equity is much more flexible, and it looks at the substance of the transaction and the reality of the facts. Obviously, another function of equity is to create property rights. So you have got a taste of it in the land law classes already. For example, when you are trying to say that you provided purchase money towards the purchase of a flat, but you are not the legal owner according to the lands registry, you may potentially get proprietary interest by establishing perhaps proprietary estoppel, presumption resulting trust, common intention constructive trust, and all the rest of it. So obviously that is one aspect of the creation of property rights by equity. Um, and the third function of equity is actually quite the focus of the equity and trust lecture or course in general, which is trust itself. By using equitable principles, we can basically set up a trust. And once there is a trust, basically then a trust means that the beneficiary placed trust and confidence over somebody else, being the fiduciary, to manage the trust asset for the beneficiaries. So there came certain duties and powers given to the fiduciary or trustees. And when there are breaches, there can be personal remedies. There can also be proprietary remedies. And sometimes when a third party intermeddles with the trust assets and there is certain unconscionability or dishonesty elements within the interference, we may even be able to establish personal liability on the parts of those third parties. So this is a really, really brief overview of equity in general. Trust, as I mentioned, is actually a subset under the umbrella term of equity. So whenever there is the reference to a trust, you obviously would need to understand different specific rules about how you declare trust and how you constitute a trust. And once a trust is set up, what are the trustees' duties and powers, and what are the potential breaches of trustees' duties, and what remedies are available, as I mentioned. So these content and maxims of equity are generally applicable in the equity world. So equity will not suffer a wrong without a remedy. Basically, it means that it tries to give remedies to the beneficiaries who suffered a breach of trust. Equity follows the law. This is something you learned in the land law class already, which is that you look at the legal position and see who are the legal owner of the flats, and presumably equity follows the law. That person would also be the equitable owner of the flats. So that's equity follows law. Where equities are equal, the law prevails. So that means that from equity's eyes, when the two conflicting interests are actually equally meritorious or whatnot, the common law position will prevail. Right, and first in time prevails. He who seeks equity must do equity, so that's why you need to come with clean hands. Delay defeats equity, so you can't have undue delay. So these are some principles we learned in contract law classes already. When you're trying to seek injunction or specific performance, you are not allowed to have this discretionary bars present. If you have these equitable bars present, then you won't be able to get any remedy from the court of equity. So equity looks at substance rather than form. This is something you learned in your company law classes or business association classes, right? The court will look at the substance of a transaction, but not just a label given by the parties to a particular transaction. Equity treats as done that which ought to be done, which is something again we should have come across in our land law classes. So that is the reason why once you sign the sell and purchase agreements of to purchase a flat, even though there is yet to have a conveyance or assignment of the flat to the purchaser acquires a proprietary interest in the flat already. That is the reason, right? So because equity would treat the transaction done, even though the transaction hasn't been completed yet, but the transaction ought to be completed once an SPA has been signed, even though the assignment is yet to be completed. So these are the various equitable maxims that, technically speaking, you should have come across in previous learning of the law and previous areas of law that you studied. So we are going to study equity and trust in substance in this particular course. So what is the importance of equity and trust? It is basically the relationship of a trust and confidence imposed by one person upon another person to manage the asset for himself. Right? So this trust and confidence can be from your friend or from a particular company that manages certain portfolio of yours. But the thing about equity and trust is it is much more flexible. It considers the content and the nature of relationship between parties, not necessarily requiring that you have a contract to govern the relationship. So this is the powerful bit of equity and trust. So now let's go to the hardcore bit of trust. So trust, in a trust there are usually three parties. First of all, you have the person usually being a wealthy guy, having a lot of assets. He wants to put those assets into a trust. So this person, we call him the settlor, which is the person setting up the trust. The settlor transfer his asset over particular property or particular sets of properties to the trustee. Trustee here being the person whom the settlor imposed trust and confidence, and the person who is obligated to manage the trust asset, the trustee. And there is obviously a person who benefits from the trust, right? That person we call the beneficiary. So in this scenario, you see the settlor transfer his title over property, maybe a flat, to the trustee. And before the transfer, the settlor made a declaration that the trustee should manage it for the benefits of a defined purpose or of a particular person, beneficiary. Then you have a trust. So at common law, the trustee agreeing to perform the obligations in the declaration, there would be a contractual duty to perform it. But the problem is the beneficiary has no contractual recourse to enforce the promise. Why? Because the beneficiary is not part of the contract between the settlor and the trustee. In other words, by virtue of the privity of contract rule, the beneficiary is not a contracting party. So he cannot enforce the promise contractually. So in order for the beneficiary to enforce it, equity says that there is a trust. Right, so by saying that there is a trust, the beneficiary has the equitable proprietary interest in the trust assets under the trust fund. So here, what it's saying is if the trustee agreed to perform in declaration but failed to perform the obligations, he will be unjustly enriched, and abuse the trust and confidence reposed upon him. So as a result, the trustee cannot insist on a straight legal rights, being the fact that there is he is the legal owner, and by virtue of the privity of contract rule, the beneficiary has no right to sue him contractually. Equity will enforce the declaration requiring the trustee to perform his duty, and as a result, the beneficiary has a corrective right against the trustee and the whole world except equity's darlings. Remember, equity's darlings are defined as bona fide purchasers of a legal estate or legal interest for value without notice. So, when equity has developed such a convenient device of trust, there are various applications. Obviously, it can be used on a family level. So, when say there's a wealthy guy having a family, and he has got a few sons and daughters and also some grandsons and granddaughters. When he is getting old, he wants to put the assets into a trust. So this is family settlement, and it is for succession purpose. Obviously, if you just leave all the assets to maybe the sons and daughters, maybe your assets would be dissipated after your death really quickly, because they will just not work and they will just spend all their time, spend all the money. So the benefits of having a trust obviously is to put the assets in trust and have somebody manages the family trust for the benefit of the family members. So these are some of the examples of family settlement. And one of the most famous cases is this TAM and HSBC International Trust Limited. The HSBC is the sole executor of the will and the trustee of this trust. So the settlor was Anita Mui, which was a really famous female singer in Hong Kong who passed away many years ago. Settlor passed the trust assets to the trustee, operated by HSBC during his lifetime, and then the trust provided her mother, beneficiary, was able to get a living expense of 120k per month, and some of the ancillary expenses, and the remaining funds were to be donated to a charity. So this is the content of the trust. Obviously, the reason why this woman Tam was really famous was she actually went to court many times asking for more living expenses when she was already getting 120,000 per month to spend, and she felt incredibly insufficient for her living standard to be maintained. So this is one example. And the other example is Khan and Otopun and HSBC International Trustee Limited again. So now the settlor was Otopun. Otopun was the husband of the previous Secretary for Justice, Um, so this set law sets up a discretionary trust to an offshore trust, holding certain shares in the settlor's company with himself and his child as the